for joining us in this webinar on transparency for the police, transparency for the courts. We are very pleased to have Monifa Bandele. Could you please, am I getting your name right?
Bandele, yes.
Bandele. Thank you. I've only ever seen it in print. And from Moms Rising and the Communities United for Police Reform in New York. And she's very much involved and active in the fight in New York to repeal 50A, which she will talk about during this webinar. We are also pleased to have Gabriel Caswell and Nikki Moore and Kelly Aviles, who will be talking about California's Senate Bill 1421. Robert Gammon is in for Senator Skinner right now, but Senator Skinner will be joining us momentarily. And then also from Measures for Justice to talk about data transparency and the need for data transparency throughout the court system are Michaela Rabinowitz and Gypsy Escobar from Measures for Justice. So with that, I think I'm going to have Monifa start and tell us about what is happening in the state of New York to repeal 50A.
Thank you so much. Thank you for having this important conversation and especially for inviting us to join on and talk about what's happening in New York. First, for some context, I'll just talk about Moms Rising and CPR, who we are. So Moms Rising is an organization of more than 1 million people working to achieve safe communities, health equity, and economic security for all moms, women, and families. We're working to dismantle the school to prison pipeline, in mass incarceration, promote things like paid family leave, earned sick days, affordable childcare, and end the wage and hiring discrimination, which penalizes so many mothers. Moms Rising also advocates for better childhood nutrition, healthcare for all, toxic-free environments, breastfeeding rights, so that all children can have a healthy start. In New York, our members are working to bring greater independent oversight, transparency, accountability, and justice for victims of police brutality and misconduct. We're members of Communities United for Police Reform, which we call CPR, which is a 70-member coalition representing communities across the state of New York. Together, though, our work has been made more difficult because New York State has one of the worst police secrecy laws in the nation. In communities across New York, women and men of color, transgender, gender nonconforming, and binary civilians are specifically targeted and face humiliation and abuse in their interactions with the police every day. So for some context, nationally, some 1,000 people are shot and killed by police every year. Yet in a 12-year period, 2005 to 2017, only about 80 officers were ever arrested on murder or manslaughter charges, out of which only 35% were convicted. And studies show, as we all know, that Black people are more than twice as likely than their white counterparts to be killed by the police. And we've seen that with very high-profile cases like Sean Bell, Eric Garner, James Powell, Romali Graham, Kimani Gray, Mohammed Ba, Chantel Davis, and most recently Shahid Bassel here in New York. Last year, BuzzFeed released leaked records for about 1,800 New York City Police Department employees who were charged with misconduct over a 4-year period. And I want to just give some highlights of the information that was leaked. At least 319 NYPD officers were allowed to keep their job even after committing offenses that NYPD leaders have always assured the public were fireable. School safety officers found guilty of using excessive force against students were punished with just 5 lost vacation days and remain on the job working with children. And anyone concerned about false information leading to wrongful convictions might like to know that more than 100 NYPD officers were accused of lying on official reports, under oath, or during an internal affairs investigation. And they were punished with as little as a few days loss of vacation. So here's the deal. There was a time when much of this information had been made publicly available. But in 2016, the NYPD suddenly decided, after decades of posting information like this, that doing so violated Section 50A of the New York State Civil Rights Law. The law states that personnel records used to evaluate an officer's performance toward continued employment or promotion are confidential. And it's constantly and increasingly being used as a tool by the police establishment to thwart police accountability and transparency statewide. The NYPD and the PBA, which is our police union, use 50A as a shield against accountability and transparency. And their uses of it are based on a seriously flawed interpretation of the law, which was never meant to be so expansive. As long as the statute is on the books, it will be used to prevent the public from learning important information about the people sworn to protect us. One of the officers in the BuzzFeed leak is Daniel Pantaleo. Before Daniel Pantaleo killed Eric Garner in 2014, he had 7 disciplinary complaints and 14 individual allegations made against him. The Civilian Complaint Review Board and the New York City agency that investigates police misconduct filed by the public substantiated 4 of those allegations. And yet Pantaleo remained on the force until this past summer, when activists escalated demands for his firing, filling the streets of City Hall and One Police Plaza, and trolling Mayor Bill de Blasio on his presidential campaign trail. Finally, I want to underscore a seldom mentioned danger that we face due to police secrecy in New York. We don't talk about police who commit sexual assault. Police sexual misconduct is alarmingly common. For context, a recent survey of over 700 cases of sexual misconduct by law enforcement personnel nationally showed that on average, a police officer is caught in the act of sexual misconduct at least every 5 days. Another found that in just 1 year, 618 officers were implicated in sexual misconduct, making it the second most commonly reported form of police misconduct after excessive use of force. But because the NYPD does not publicly disclose information about complaints of sexual misconduct that it receives, the scope of this crisis in New York is frighteningly unknown. But one study surveying almost 1,000 youth in New York City found that 2 out of 5 young women had been sexually harassed by police officers. I want to share one high-profile incident to reveal a troubling problem that must be addressed. Many of you have heard about the appalling account of 2 NYPD officers who raped an 18-year-old girl in the back of an unmarked van. This case sparked outrage and resulted in the officers facing criminal charges. Disturbingly, they defended themselves by claiming the encounter was consensual, even though the teenager was in police custody. Eddie Martins and Richard Hill were never fired from the NYPD. And even though they resigned and were found guilty of bribery and other misconduct, they were acquitted of rape. And their disciplinary records prior to this incident are secret. Frighteningly, so are the records of countless other officers with sexual assault complaints. We must repeal New York State Civil Rights Law 50A. Access to disciplinary records and documents are essential in gaining transparency around police misconduct. We need transparency for justice and safety in the same way that we have access to public, disciplinary, and misconduct records of doctors, lawyers, and other professions that should be accountable to our communities. So I would love to take any questions or additional comments, but that's kind of an overview of what the situation here is with 50A. I also want to say that we're working really hard on a repeal bill that will be introduced in the next legislative session. I hope that if there are any members of the New York State Legislature listening, that they will sign on as sponsors to the Bailey bill. And we're always open to answer any questions or concerns that people may have about this repeal legislation. But we are working for a full repeal of this unnecessarily secret law.
I had a question. Was this bill introduced previously? And if so, what happened to it? Or where did it get caught up in the legislature?
Yeah, we were really excited last year when it was introduced, and we also felt that we had the numbers, so to speak, in our state legislature to pass this bill. But Sadly, it did not pass. And one of the things that was challenging was what we call fear mongering and a lot of misinformation. Some people characterized our bill to repeal 50A as a way to expose not personnel records, but personal records of police officers. So, legislators and the media were kind of like flooded with questions about the safety of officers if their personal information was made public. People can find out where they live and where their kids go to school and these types of things. This bill would not do that. We're hoping we will definitely do a better job this year making sure to squash a lot of that mythology, but that was one of the things. And then also in New York State, our police unions have a tremendous amount of political power with our elected leaders. And so we have to also demonstrate to them that it is safe to support this common sense piece of legislation. And we believe we're getting there.
Great. Are there any other questions from the panelists before I move on to Senator Skinner, who's now joined us? Well, if there are any questions, I did just want to say there's a chat along the side, and somebody did post along the chat a link that we will make available to people. It's a link on KQED, which is our local public station, about previously secret records of California officers. So if anybody has any questions now or later, please just post them. So with that, I want to introduce Senator Nancy Skinner, the author of Senate Bill 1421, to talk about that legislation in California, which pierced the veil of police secrecy a bit.
Thank you, Kate. And I want to thank Monifa for her description of the circumstance in New York and why such disclosure of police records, especially around police misconduct, is so essential. For so many reasons, just to ensure that we can hold our officers accountable, to ensure that our agencies are not hiding bad officers. And there's just many, many reasons. Now, while I am the author and the bill was under Senator Skinner, in fact, it was really a huge coalition that came together and brought me that bill. I'm not the first legislator in California to try this. California, unfortunately, was the most secretive state. We had a 40-year ban on any and all public access to records related to police conduct. So if you compare that to California's Public Records Act, where almost every other public official, whether you are a street sweeper, a librarian, a city council member, any state employee, with a little exception with legislators, but other than that, any other public employee in California, you could get every record about them almost. There was pretty much no limitations on your ability to, under the Public Records Act, to get this information, except for law enforcement. There was a 40-year total ban. And so we were really an outlier because, of course, there's about 25 other states that have either complete access or limited access. So for many, many years, the California legislature has been trying to address this problem. And prior to me, a former Senator, Mark Leno from San Francisco, had attempted twice to open up these records. And prior to him, a senator back in the early 2000s, Senator Gloria Romero, had also tried to bring public access. All of those efforts failed. The entire law enforcement community, every single law enforcement union, opposed those bills, and they were powerful enough that those bills did not get through the California legislature. Now, I think that we were uniquely situated for a variety of reasons, partly because it had been tried multiple times, very often, at least in my experience as a California legislator, that once you try a difficult bill a couple of times and you've created the conversation, you can eventually wear people down and bring an openness. But the coalition that brought me the bill was essential. It was the Newspaper Publishing Association, it was the ACLU, all of the groups involved in Black Lives Matter, all of the groups who were organizing against police shootings, primarily of Black and brown individuals, all of those groups and organizations up and down California were united around this bill. Now, the other benefit that I experienced is in the same year that I introduced my bill, we had, like everywhere across the country, more and more Californians were becoming aware of the police shootings, especially against Black and brown residents who, unarmed, seemingly because of the video that we would get from passersby, seemingly unprovoked, unarmed, just this travesty of police shootings. And at the same time that I was carrying my bill, one of our very prominent legislators from the state assembly introduced a bill to change the entire guidelines for how an officer, under what conditions they could use their weapon. And this was so controversial. And Assemblymember Weber introduced this bill at the point that Stephen Clark was shot as he jumped the fence to go into his grandmother's, in effect, in his grandmother's backyard. And he was unarmed, and yet he was shot dead. And so there was so much response to that shooting and to Assemblymember Weber's bill that the police unions, all the law enforcement agencies were, in effect, they were almost in a conflict as to where do they use all their political capital to stop the change in how police could use force, or my bill. And we were able to, we never got any of the law enforcement unions to support my bill, but we got the DAs and the police chiefs by narrowing the bill so that it only covered those incidents of sexual misconduct on the job, use of force, and tampering with evidence or tampering with the witness. So it's a pretty narrow bill, but they're very essential officer misconduct, the things that you would have such a hard time, anyone rational would have a very hard time arguing against public access to that type of information. So with in effect, the distraction of the use of force bill and the support of both the police chiefs, the DAs, the Newspaper Association, ACLU, and all the other civil rights groups, that's how we got it through. But it really did take a village. And now what we're finding, and I'm sure, Kate, some other folks are going to talk about this, what we're finding is that because of the Newspaper Association's backing of the bill, they have been very, very aggressive and diligent about trying to get access to records from agencies across the state. Agencies have stalemated. Many, many agencies have not released record number one. And unfortunately, our Attorney General was not very helpful at all, which really upset a lot of us because he is a Democrat. This was something that we expected him to be strongly support. He was good. He's been good so far in filing briefs in support of the law, but he has himself refused to release certain types of records. So that's not helped a lot of things. But back to the Newspaper Association, many journalists joined together and poured through the various records, and in addition had access to some information around some officers who had been previously convicted of crimes where no one ever knew that these officers were convicted of these crimes, and all of them were still working as law enforcement officers with different police departments or law enforcement agencies in California. And these journalists have now gotten all the records, and they have shown this pattern of people with criminal convictions that in many, many professions in California would be prohibited from being able to practice in that profession, are still carrying weapons and with a badge and operating as officers. So it's been eye-opening, and we're going to have to see what happens next, what type of legislation gets introduced to limit this. But there's one particular community in California, McFarland, where over half of the officers have been convicted of very serious crimes and are still on the force. So the bill's disclosure has already been extraordinarily helpful, and we'll have to see what kind of follow-up legislation that occurs now that we have a lot of information due to these records being released. The other thing that we are trying to get our district attorneys to do, because California's ban was so extensive that a DA had no ability to get records. So you could be in a case, either the public defender or the DA, and a officer could be providing testimony, and that officer may have had a whole history of tampering with evidence or tampering with witnesses, and that would not have been disclosed to either the public defender or the DA, and they would have no ability to get that record unless there were criminal charges actually against the officer. So now we can get those records, and we are strongly encouraging DAs to, across the state, get these records, because we do not want to be in a situation where officers are testifying, officers who have already been compromised and who legitimately should not have standing in the court because of their past history. So we are now working on that. And of course, the interesting thing, as much as there are bad apples that we have exposed through 1421, the vast majority of our peace officers who have excellent records have not used serious force, and there are not, and with 1421, bad things are not being disclosed about them. But that handful for whom we are discovering these bad things, they continue to be on the force, and that's what we really want to do something about. But anyway, to wrap up, the ongoing problems that we're having, as much as the legislation has been successful, as much as many families, for example, who had loved ones who were victims of officer shootings have now been able to receive the records and gotten a much better picture of whether the situation where their loved one was shot, how thorough the investigation was or wasn't. And it's helped to, I can never say quite bring closure, because you can't bring closure when you have lost a loved one to an officer shooting, but at least has brought, it's like you have a hole if you can't ever get those records. So many of those families now have the records, which is a great thing. But what we are facing still is that there are many local jurisdictions that are not releasing at all. There are others who are charging outrageous fees, and under California's Public Records Act, the agency is allowed to recover their costs for duplicating the materials, for example. But that is, they're not supposed to cover their costs for the labor involved in it, just for the duplication, which in all cases should be quite reasonable and not very expensive. But these agencies are trying to charge outrageous amount of monies to discourage the release of the records. And then we have ongoing lawsuits that are challenging the law. So far, the vast majority of judges that have ruled on the legitimacy of the law have ruled in its favor, with a few outliers. The vast majority have. But those are the circumstances we're facing in trying to see this great law really come to fruition.
That's great. Thank you. I do just want to read some of, there was a question that was directed both to 1421, it sounds like 50A, and thank you, Nikki and Monifa, for answering it. I did just want to say it since we are recording this, and I'm not sure if the chat will be part of that recording or not. I just don't know. But the question was about how this protects an individual's personal information, or maybe perhaps like an individual's privacy, maybe a witness in a report, a witness's name, and other identifying information. So Nikki and Monifa, could you answer that for your respective pieces of legislation? Maybe first Nikki for 1421.
Sure. Hello, everyone. So the law that we crafted was really balanced, and it protects the identity of an officer's family members, their home address, anything sensitive and private. That's to be redacted from the documents, and the same for witnesses as well.
And that's the same in New York in our repeal bill. The only thing that would be, exposed to the public is information related to misconduct. And so I think that's really important to underscore. Oh, he says family member information related with officers' conduct. Right, so I think that's what we think are witnesses of the protection of witnesses in a particular incident. All that information would be redacted and is protected even once we repeal 50A.
And even in sorry everyone, this is Gabe Caswell. I worked on 1421. Even in the 1421, we even allowed for limited redaction of an officer's identity if there was a balancing test, a strict balancing test that we crafted. So that's an additional protection that we did take as we sort of kind of got to the end of the process.
Kate, you're muted.
Thanks. So there's, I'll try to answer all questions or get our panelists to answer all questions as we move on.
I wanted to say one more thing
sure.
about Edwin's questions especially. So in New York State, this law was already on the books for years. What we're experiencing is a hyper-conservative interpretation of the existing law. And so your concern about it opening up a loophole to investigate civilians without consent, I think is an important one, but you have to understand that how this law is being applied is what the issue is, and that even when it was in place, prior to it being interpreted in the way that it's being interpreted, this information was public, and we did not see, a huge amount of the use of civilians' information used without their consent or shared without their consent. So thanks for asking those questions, but I think it's just really important in our case in New York State to say, what's really behind our repeal is that we have an administration that's interpreting the law in a way that is really damaging.
Thanks. I'm going to move on now to actually to Kelly, and if you could talk about Senator Skinner did mention the litigation that's been going on around 1421 and some of the concerns around really efficient production of these records for so many people that have been waiting for these records. So if you could talk about the litigation and about some of the issues around disclosure. I know there's been very much in the news recently around some records that were released. So I'll leave it to you. Thank you. And I think you're on mute. Are you on mute?
Not anymore. So we've been actually dealing with this, the legal issues surrounding 1421 since it was enacted before it actually took effect. So before it even took effect, one of the larger police unions filed a challenge directly in the California Supreme Court, hoping to bypass the other, our normal procedures, asking for the court to find that the bill would not apply to any records or incidents that happened before January 1st, 2019. The court rejected that, we assume probably because of the procedural aspects. And it would have actually been easier because what we faced later was dozens and dozens of police unions filing lawsuits in basically every county up and down the state, trying to stop the disclosure of these records. A number of people were involved. I handled a number of the cases. There were there were a number of other partners, the ACLU, other law firms that worked tirelessly to combat these challenges, which were all expedited and happened very quickly. So in January, we saw most of these cases were filed within the first month. So they claimed that for two reasons, that because the law didn't specifically say that records that were created or incidents that occurred before 2019 were to be disclosed, even though that's not the way we would normally interpret a statute regarding disclosure. And there was lots of stuff in the legislative history about what the law was intended to do. They said that the records shouldn't be disclosed and that it should only apply going forward. The courts largely rejected that, and very quickly. There were some courts that heard the matter within a matter of weeks. It was appealed, and by February, we actually had rejections from courts of appeal and the Supreme Court, all saying we're not going to stop the disclosure of these records. So that was excellent. I'm overwhelmingly, the courts did a great job getting to these issues very quickly, which is hard because in California, as I'm sure in New York, the courts are really bogged down, and it can take a long time for issues to make their way through. So the fact that we were able to combat these so quickly was great. However, there were a number of cases that are still lingering. So, for example, the Attorney General had refused to disclose records, claiming the same thing that all the police unions argued. And so their lawsuit is now in the appellate court. They lost in the trial court. The appellate court proceedings are still pending. They've now asked some questions about how do they interpret the redactions that are allowed in 1421. So they're still in the process of handling that case. There was one case where the unions won. There was a case filed in Ventura County, and the judge seemingly ignored the other rulings from the other courts and the substantive arguments, and just basically said, I think somebody other than me needs to rule on this issue. And so I'm just going to go ahead and I'm going to rule in favor of the unions, and then it can be appealed. Unfortunately, that has now made this one county completely different than all the other counties that are now having to comply with the law. And the union took the extraordinary step of filing for attorney's fees against the public defender who was trying to enforce this law. I think I have confidence that in the end that this will get resolved correctly. However, it has caused a number of problems in the meantime. For example, we had a public records lawsuit in the county of Ventura that the information we were seeking would have been made disclosable under 1421. We thought it already was, but for sure, once 1421 was enacted, it should have been disclosed. That has now been held up pending this lawsuit. So these kind of procedural hurdles can create kind of havoc for people that are trying to get these types of records. There is another case in Sacramento where the court where they refused to release records, claiming the same thing, that 1421 shouldn't apply to records that predated its passage. That case, they've won that case. However, once the judge issued an order to force them to disclose the records, they stalled and delayed and then narrowly interpreted the way 1421 read in order to try to get around definitions that seemed like they should have been crystal clear. For example, they argued that great bodily injury should be narrowly defined, even though there are a number of cases that talk about what great bodily injury is. So that they just recently lost that issue again in the trial court. I don't know where that will go. It looks like they're ordered to produce immediately and return to court in December to give the judge an update about where they are. We also have cases now, we've moved into trying to compel disclosure. As you heard Senator Skinner say, agencies have just refused to disclose records, some of the largest agencies. So we have a case in LA County against the LA County Sheriff's Department. The ACLU just filed a case against the LA County Sheriff's Department because they have released maybe a handful of records in the past year. A lot of places have complained that it's put an extraordinary burden on them going back and having to disclose these records, which there is some burden, certainly, but when we consider burden in terms of disclosure, we talk about, the public interest in disclosure. And here, I think that the public interest is so paramount that it's hard to say that any amount of work required to get this information to the public is too much. These are serious issues that the public really has a right to know, so they can talk to the people in charge about, how are law enforcement issues being handled at their city, in their county. And people just don't have the information right now to do it. And so delaying this has only created that much more of a problem. As Senator Skinner said, we recently found out that there are many officers that are still employed that where there have been serious issues of misconduct. And we don't know. For example, even if a police officer is transferred from, for example, if fired from the department where it happens, they can be picked up by another department, and the citizens in that area don't know. And so until this becomes a blanket disclosure from all the agencies, which I really hope that these issues will be limited to the past records, and going forward, we'll see less of these complaints. But we've also seen some indication that may not be true. So in the city of Fullerton, we have evidence that they've gone back and revised settlement agreements with officers to actually include information that they agree not to disclose records under 1421, and they revise the findings. So they say this won't be disclosable. You don't have to worry. And that kind of, those issues, I think, have only further eroded trust and really, at least in my opinion, have made it clear that we need even more disclosures, because now it's not that we can trust that we're getting the information that's supposed to be disclosed under 1421. We have to wonder whether agencies are sustaining findings they should have sustained, whether they're investigating complaints they should have investigated, whether they're going back and revising findings to make information not disclosable, whether they're narrowly interpreting the request so that they don't have to release examples of great bodily injury. We had one where somebody went to the hospital with a broken arm, and the agency claimed that wasn't a great bodily injury. So, all of these things have been ripe for lawyers to try to find loopholes when the intent of the law was crystal clear. So I think those are definitely some of the challenges that we've been encountering.
So Kate, I want to make a few clarifications. So everything that was described is accurate. For those on the webinar that might be thinking about either a bill that would open up records, or say in the case of New York, their repeal of a bill, I think it is worth it to look at what the arguments have been in relationship to 1421, because, for example, this issue of whether so California's laws work where when our legislature passes a bill and our governor signs it, the bill's effective date is the January 1st of the following year, unless the bill specifies otherwise. And so normally people expect, okay, then the law only applies from this date on, not the past. But what we were doing with 1421 is we were amending California's Public Records Act. And California's Public Records Act is not a time-specific law. It is a law that governs things, material or files, documents that are in an agency's possession, regardless of the date. So we didn't specify that the records, that 1421 would make records only within this time period or something eligible. We just said records are eligible. And so it's records that are within the agency's possession. Now, partly we did that in 1421 because California has a separate law that only requires law enforcement agencies to retain records for, Gabe, you're going to have to help me here, 10 years? Is it, oh, 5. So yeah, so we already have a ridiculously limiting law where law enforcement agencies can literally dump records after 5 years. And so we didn't want to specify a time period. We didn't want to encourage the dumping of records. Now, of course, what happened is, as was described, first we had agencies say, oh, all their records from the past don't matter because the bill didn't go in effect till this day. But one thing that was to our advantage is a couple of law enforcement unions that opposed the bill wrote a letter and testified while the bill was being debated, where they basically asserted that, of course, the intent of this bill would be retroactive and in its effect, that it would cover all records in an agency's possession. So having that helped us because, of course, that was the intent of the law. So, of course, we have provided that to the courts in these arguments. But what we found is the following things. One, agencies arguing that it's not retroactive. We found agencies before the law went into effect starting to dump records. So in other words, agencies that had records from past their prior to the 5 years where they were mandated to hold them, they started dumping them so that the public could not get access to it. So we had a couple of those things which, unintended consequences of any law. But finally, I would say that our Attorney General, the Attorney General has sworn peace officers within his own staff, and he was willing to release the records related to those people and did admit that the bill applied to them. Where he has so far said that he doesn't have to disclose records is records that are in his office's possession that emanated from another agency. So the officer was actually an officer of a different jurisdiction and the misconduct happened in the different jurisdiction. And our Attorney General has argued that it's that jurisdiction that must release the records, not him. So that's the difficulty we've had there.
Thank you. I did want to get back to just a question for Monifa, because a question came up around 1421, whether it applies to all correctional, to all law enforcement. The bill to repeal 58, does it apply to sheriff's deputies, correctional officers in jails and prisons in New York, or is it just certain police departments?
Yes, it applies to all peace officers as well as fire department officers, well, employees of FDNY.
Okay, thank you. Thank you. And is that the same for SB 1421? Does it apply to fire department?
It would not apply to fire departments, but they would be regulated under a separate. They weren't protected to begin with. They aren't protected under California's laws that give secrecy. And just sort of for quick, 10-second background on that, in 1974, we had a decision by our California Supreme Court that clarified that people in criminal proceedings could get access to records that may assist them in their defense. And so all of our secrecy laws were essentially put in place as a result of that decision. The legislature gave a number of protections to peace officers. They never afforded those same protections to other state workers or government workers. Teachers weren't covered, firefighters weren't covered, so we don't have anything really to undo there.
Great. We are going on past an hour for questions, so I'm going to want to get back to people talking about the sort of the legislative struggle around 1421 and maybe more on the legislative struggle around 50A, though it's still ongoing, as well as on how the coalition was built. But I do want to move on right now to Michaela and Gypsy to talk about criminal justice data more generally in the courts and in the jails and in the prisons and throughout the criminal legal system, in prosecutors' offices. This is Michaela Rabinowitz and Gypsy Escobar from Measures for Justice.
Great, thanks so much, Kate. So I will start and I'll talk a little bit about what are some of the issues that create barriers to criminal justice data transparency, and then Gypsy will talk about some of the work that we and others are doing to address these issues. And just for a little bit of overview and context for those of you who aren't familiar with our work, Measures for Justice is a nonprofit criminal justice research organization. Our goal is to close what we call the criminal justice data gap, and that gap encompasses both the existence of criminal justice data as well as access to that data. And so we both do data collection, data analysis, and standardization, as well as do work related to transparency, helping jurisdictions address some of the gaps in the data available, as well as think about how to make sure that the data is collected and stored in a way that makes it accessible and usable. So just in terms of general issues with criminal justice data, in many ways, the issues with criminal justice data reflect the larger issues with the criminal justice system in general, which is to say that criminal justice data, just like the criminal justice system, is extremely decentralized. So while each state has its own set of penal codes, the way in which those are implemented varies very widely across counties as well as across cities. And the same thing is the case for almost all criminal justice data collection. So there is very limited standardization regarding what are the pieces of information that law enforcement agencies, prosecutors, defense agencies, sheriff's offices and jails, or courts should be collecting. There's very little guidance around how they should be collecting the information. And so often, one of the challenges we will see is that, for example, two different law enforcement agencies will track the same offense in two completely different ways, either because of manual entry of some of the information, because of using statutory codes versus offense descriptions, things like that, that limit our ability to actually standardize and understand what is happening similarly across jurisdictions, even within the same states that have the same laws. There's very little oversight and centralized reporting of the information that is collected by those local agencies. And so, across the country, we have over 3,000 counties. We like to say that justice is really happening in over 3,000 different ways across those 3,000 counties. So we have 3,000 prosecutors' offices that are responsible for interpreting the law, that are also often responsible for making decisions about what piece of information about how prosecutorial decision-making happens are tracked, as well as how that information is then made available to or shared with others. So the data collected by the different agencies, often not done in a way that can be tracked, for example, even a given person within a jurisdiction across different agencies. And so we may know a certain number of arrests happened in a jurisdiction. We may know that a certain number of charges were filed. We probably can't connect those arrests to those charge filings and really can't understand how the full criminal process is operating. I think the other really critical piece of information and really critical challenge is that there are very widely varying state laws regarding what is included in public records acts across different states. And then even within those states, very widely varying interpretations of those laws. And so just like Kelly was describing in terms of how different counties are interpreting 1421, we see the same thing when we look at, for example, within California Public Records Act. We see the same thing when we look in California, for example, at the Corey laws, which are the state statutes in California that govern access to criminal offender record information. Within one jurisdiction, you may have a sheriff's office that says California Public Records Act only allows the release of arrest records within a certain time period, and you may have the neighboring jurisdiction having a completely different interpretation of what information is available under CPRA. The same thing under other state laws governing the collection and access to the information. And at the end of the day, the only way to address those differing interpretations is ultimately through litigation, which is not a strategy that Measures for Justice engages in, but also more generally for most people, for most practitioners, for most folks who are interested in understanding how the criminal process is operating, researchers, journalists, et cetera, that's not really a feasible approach to litigate every time an agency has a different interpretation or a restrictive interpretation of Public Records Act. I think a couple other critical challenges that we see in criminal justice data transparency. So one is related to court records specifically. So in some states, we see that court records are considered part of that state's public record statutes. And in some states, we see that court records are subject to a completely different set of public records laws, or have their own court rules regarding which elements of court records can be accessed in what context and by whom. We see huge limitations in access to what's called bulk records. And so even if the court rules are understood to be part of the public record, to actually access those, you would literally have to go down to the courthouse and request those records one by one, often with a case number or with a person with the name of a defendant, the name of an attorney, et cetera. But if you actually want to be able to collect the information to understand what are the trends that are happening in the criminal process, who is being charged with criminal offenses, who is getting bail set in what amounts, who is actually making bail, that information often is either non-existent or cannot be accessed because of limitations in bulk record access. And then finally, one of the things that we see in trying to collect data on the criminal process is often a tension between privacy and transparency that can act as a barrier to transparency. So for example, sometimes in certain states, we see laws that limit access to information on criminal cases that did not result in a conviction. And so while obviously we recognize that the individual people's confidential information should not be accessible, by not allowing access to information about cases that did not result in a criminal conviction, you completely undermine the ability of researchers, policymakers, and practitioners to accurately understand how is the criminal process operating in that jurisdiction. Who is being charged and then having their cases dismissed? Are there systematic differences in who is arrested for an offense and ultimately not charged? Are there systematic differences in who charges are filed against, who then have their cases dismissed? Are there systematic differences in who is convicted of an offense at trial versus in a negotiated plea? And without access to data on really all aspects of the criminal process, it's really difficult to see where biases occur, as well as how the process is being implemented differently across different jurisdictions. So Gypsy, I will turn it over to you to talk a little bit about some of the work we're doing to address these issues.
Thank you, Michaela.
And just before, I did just want to say, I think Monifa, you had to leave at 2, so I just wanted to allow you to say goodbye if you want to.
Yes, at 5, I have to get on right into another call. So okay. Thank you. So I have a few minutes, but I'll quietly step out when the clock strikes 5.
Yeah, thank you very much. Thank you.
Thank you, Monifa. As Michaela was saying, the issue of data and transparency in criminal justice goes across practice areas, right? It's not just an issue of policing, but it's an issue across all the stages of the process and all agencies of the system. So in 2011, Measures for Justice was created with the idea that we got to do something about this. We're created with the idea that we tend to know relatively a lot about what's happening in the criminal justice system of large, urban areas. We know a lot about, and I should say a lot, about what may be happening in Los Angeles and San Francisco and New York City and, Miami and, the big metropolitan areas, but we really don't know what's going on in smaller urban areas and definitely rural areas. So we don't know what's happening in, say, Rusk County, Wisconsin, right? Are there, egregious racial disparities happening there, or do they actually have a diversionary program that is extremely successful and could be available to other jurisdictions to learn? So we set out with the idea of, pushing the country towards closing that data gap in criminal justice transparency and criminal justice knowledge. So we've been collecting data primarily from the courts, but also from prosecutor offices and departments of corrections. In 2017, we launched our public data portal. If you go to measuresforjustice.org and click on the data portal, you'll see data there for 6 states right now. And we are going to be adding 14 more states by the end of 2020. So by the end of 2020, we'll have measured 20 states. And we're not collecting data just for the sake of data. We actually develop a number of metrics that are attempting to get at the performance of local criminal justice at the county level. So that's one of the things that we're doing is our public data portal, which has had kind of like unintended consequences, positive ones, in terms of following what we do have this motto that data breeds data. And we do have a couple of examples where that has actually happened. So in 2017, we published, Florida was one of the states that we published, all created, all the metrics using court data. And the then chair of the House Judiciary Committee came across our data portal, and he was actually already starting to look into what data were available from criminal justice agencies across the state, because with that we cannot really evaluate whether reforms are having the intent that they are, that they were created to do. So Representative Sprouse reached out to us, and basically, he told us, okay, tell us where you got all the data, which agencies denied you data, why data is not being collected at all by any agency in Florida, and what is your dream list of data elements that all criminal justice agencies should be collecting, not just in Florida, but across the country. So we did that work, we sent them the information, and that turned into a bill, SB 1392, which was passed in 2018. That bill was then amended this year in HB 7025, where we helped them kind of like clarify a lot of data element definitions. And what these bills do, they basically mandate court clerks, prosecutors, public defenders, jail administrators, and the DOC to report a set of data elements that are defined uniformly across counties and across jurisdictions within the state. And they're to report them to a central repository. In the case of Florida is the Department of Law Enforcement, which is to aggregate all the information, link cases across agencies, anonymize the data, to remove all PAIs from defendants, and then make that data at the case level public for anybody to download and analyze and produce reports and bring anything to the attention of the government of Florida. So that bill kind of created momentum for transparency across other states in the country. There were other legislative initiatives in the last year in other states. As you know, some passed, Connecticut, we were not involved with that, but Connecticut passed a law to requiring prosecutors to report certain data elements. And Colorado passed one that required jails to report data at the aggregate level. And there's a couple more states that are working on this in a kind of like having an incremental approach, focusing in a practice area at a time. Florida was incredibly ambitious. They require all agencies to report the data, but Florida also had a very different kind of like, public access culture, right? They have the sunshine laws. So the agencies there, they were already used to making this information publicly available and reporting it to the state, et cetera, et cetera. So it was a little bit of a less steep Hill in Florida than it is in a place like California, where those laws have not been in place for a while, and there is a lot of decentralization. So we are hoping that this momentum for transparency in criminal justice legislation keeps churning more of these bills. We're advising a couple of states on the bills that they're working on, and we hope that this will really lead to not just more transparency, but actually better data, right? Like data that is really apples to apples, that people can use to evaluate reform at the state level across all the jurisdictions within that state, and things like that. Other things that we're doing, as Michaela explained in the beginning, we've put a lot of work on figuring out a standard operating procedure that will allow us to take data from multiple jurisdictions that have different state laws, that have different practices, different terminology, and standardize all that data into a common data dictionary that will allow us to do measurement, apple to apple measurement. So as part of that, we've developed a number of standards in terms of what are the key data elements, how those should be collected and measured. That has led to a couple of other efforts. One of them is with a large partnership with the National Center for State Courts, which this year spent a lot of time, actually they started last year, but this year and last year put together several working groups to identify what are the data elements that all the different court areas should be collecting. So we're very much involved with the criminal justice work area, but they were also working on like what civil courts should be collecting and making public, what family courts and probate, et cetera, et cetera. So they're trying to bring more uniformity to all the legal system. The Uniform Law Commission, which is a very old organization that basically produces model legislation for the states. We'll also be discussing a criminal justice data uniformity bill in the coming year. So that could also bring additional legislation across the states. And the Bureau of Justice Assistance just gave the Council for State Governments and a large partnership, which we're part of, a grant that they call the Data-Led Governing Grant, which basically is meant to kind of reach consensus around the standards of the type of data that criminal justice agencies should be collecting and making public, and then figuring out kind of like dissemination and implementation of that. So we'll be working with CSG on that next year. And lastly, there's another thing that we are doing to bring more transparency to the systems. We're working with prosecutor offices to create public dashboards. So some of you may be familiar with the public dashboard or public data portal that the Philadelphia District Attorney's Office made available in September. So we're working with other prosecutors' offices to replicate that effort, to make sure that they're bringing transparency into particularly prosecutorial decision making. Hopefully, we can push them into making more or to opening the black box that is plea bargaining, and in terms of plea offers and bail recommendations, sentencing recommendations, and things like that. So those are kind of like the initiatives that we're taking on right now. And we just hope that the momentum for transparency legislation stays alive with this crazy news cycle. But we do encourage everybody to support it.
I had a question because we do have a number of people on here from New York State. Can you just speak briefly about what New York State's transparency laws are like, to the extent that they exist?
So there are none quite like Florida's, right? What we know is that the Office of Court Administration collects data only for the 13 largest counties. And, to make it available is a lengthy process. Like Michaela explained, is guided not necessarily by law, but by court regulations. The prosecutors, I don't think, are mandated to make anything public. Neither are, basically any of the other agencies. So with the bail reform that passed this year, we know that there have been several organizations out there that were trying to put together a pretrial data bill that will allow for the evaluation of the bail reform effort. Last we heard, like the one organization that we're working with that kind of fizzled and they changed their focus to other areas. So we're hoping that in the near future we can kind of like make the connections here in New York to work on a transparency data bill.
Thank you. Were there any other questions from other panelists or anything that people wanted to say that they felt they didn't have a chance to say or wanted to emphasize in this discussion? No? All right, well, we will be posting this on Facebook and a link to it on our website, and we will also be posting links to Measures for Justice, to Senator Skinner, to Moms Rising, and to Monifa, and to, I'm not sure that the links to the California legislature would assist anybody that much, but it's there anyway, so that you can contact these organizations if you have any more questions or want to get involved or are interested in perhaps authoring legislation yourself, or if you're a journalist and you have follow-up questions. So thank you very much. Thanks to all of our panelists. And we hope to see everyone here again for our next webinar.
Thank you, Kate.
Thank you.
Thanks, Kate. Thanks, everybody.
Bye, everybody.
Bye. Thank you.